Namaskara and welcome to BIC Talks, a podcast brought to you by Bangalore International Centre, where we present conversations that move, inform, and encourage discourse.
There's one author who said, the time they are prepared to waste in discussing matters with each other is the essence of democracy. The whole concept of democracy is an open and shut pattern. Is the most misleading concept. Democracy has no fixed boundaries. Democracy is always an evolving or constricting, expanding or constricting thing depending upon the civilizational pressures, energy sources. My goodness, to encapsulate it as some doctrine is the first fallacy we make, that is a fixed doctrine.
Welcome to None Wiser Than the Law, a series of conversations with Justice MN Venkatachaliah covering the law, his life, politics, and the Constitution. The title of this podcast comes from Aristotle, who said, "To seek to be wiser than the law is the very thing which is by good laws forbidden." The role of a judge is therefore not to presume wisdom, but to unearth the wisdom of the law. Justice Venkatachaliah quotes this aphorism in a judgment, and in this series, we explore his judicial philosophy that shaped India's jurisprudence. My name is Alok Prasanna Kumar, and I'm a co-founder of the Vidhi Centre for Legal Policy. I had a chance to speak to former Chief Justice of India, MN Venkatachaliah, in August 2023. In our conversation, we covered a range of topics, from his beginnings as a lawyer to his tenure as a Supreme Court judge, his landmark judgments, and his views on developments in law and society. In this episode, we will speak to Justice MN Venkatachaliah about his career as a judge of the High Court and the Supreme Court of India, and as the Chief Justice of India, and his subsequent post-judicial career. Justice Venkatachaliah was elevated as a permanent judge of the Karnataka High Court on 6 November 1975. In October 1987, he was elevated to the Supreme Court of India to become only the third judge from the Karnataka High Court to have been appointed a judge of the Supreme Court of India. As the senior-most judge of the Supreme Court of India in February 1993, he succeeded Justice L.M. Sharma as the Chief Justice of India and held that position until his retirement in October 1994. In his 20-month tenure as the Chief Justice of India, Justice Venkatachaliah initiated a wide set of reforms that are remembered to this day. In this conversation, we go into his judicial career.
There's a very interesting story. Ram Jethmalani wrote an article, Justice Krishna Iyer in the gobbledygook. And I think Krishna Iyer himself responded through one Mr. Menon. I suspect the language of Krishna Iyer himself. He was a very fine friend of mine. One Menon wrote a reply article, Ram Jethmalani and his gobbledygook. It's a very interesting article. One sitting judge, brother judge of Krishna Iyer, wrote a scathing article in Krishna Iyer's style. And later on, many people began to imitate that style. Imitate Krishna Iyer.
You can't imitate Krishna Iyer.
He's inimitable.
Inimitable, yes.
And he's a great personal friend of mine. I have attended almost all his birthday celebrations in Cochin. Once the Corporation of Cochin celebrated its 90th birthday and invited me to be the chief guest. And it's a fascinating experience. At 4:30 in the morning, I was to get up the next day to catch a flight to go back to Delhi. And 6:30 or somewhere was the flight timing. So 4:30 when I was coming down the steps, Krishna Iyer and his daughter were standing there to receive me at 4:30 in the morning. He wrote an 18-page introduction to somebody who wrote a book on me. He wrote a 18-page foreword to it.
You met the law minister, Shiv Shankar.
No, I didn't meet him. He was seated in the room. He asked me to call on the Prime Minister. I told him meeting the Prime Minister is always a matter of honor, but I have no invitation from him. No, every judge pays courtesy call on him and all that. It sounds a little irksome for me. And I told him, you're yourself a judge. Do you think this is a proper thing for a self-respecting judge to do that? He said, this is a convention. I told him, Baba, I feel very uncomfortable. Meeting a Prime Minister is always an honor. And that man was a very charming person in those days.
This was
He
Prime
looked
Minister
up
Rajiv
at
Gandhi.
Rajiv Gandhi. He said, you declined to do that. I said, you are putting words into my mouth. But if you want a straight answer, yes, I will not call on him. He said something about how unwise I am in taking the stand. I told him, leave that to me. Please don't worry about this thing. He went and told something, I don't know what he told. Parashan was the Attorney General. It appears Parashan, that second day night, he telephoned to me at 10 o'clock and said, Rajiv Gandhi's Prime Minister sent for me, and Parashanji, I am proud to be Prime Minister in a country where there are judges like this. Before he withdraws his consent, please announce it. This is what Parashan told me. It shows the Prime Minister in a far, far beautiful light than the obstinate judge that I was.
No, which is what I want to sort of ask you about. What did it make you feel uncomfortable that you'll have to go and meet the Prime Minister for to become a Supreme Court judge?
You see, if he invited me, it would have been a very pleasant episode. Certainly, like meeting people is not a bad thing. Certainly, I enjoy meeting young people who ask questions you can't answer. It's such a fascinating world. It's a fascinating world of human relations. My goodness, I feel so excited about the excitement of human relations.
I was sort of thinking about, did you feel that you were being pressured to meet the Prime Minister?
No. He also hinted the wisdom of doing it.
Okay.
I was such an unwise person. I couldn't be educated.
Of course, when you made the shift to the Supreme Court, you would have lawyers from around the country.
All over the country.
All over the country.
And there was one Jabalpur lawyer, criminal lawyer, he used to appear for KPS Gill. He's a very fine lawyer. Gill and I had a very big, tough fight in the court.
Okay.
You know.
This was regarding which specific
His killing fields of Punjab.
Punjab. Right. Okay. In those cases.
He went and told the Prime Minister, I think I was Chief Justice. He is a madman. He says that he'll remove you from my office. And he made a complaint to the Prime Minister. Prime Minister has said it in writing. He said, no, he didn't say he put it in writing. Prime Minister told him he had put it in writing or I would have dismissed you.
Oh, wow.
He came to my house.
KPS Gill?
Gill.
Oh, okay.
In Bangalore.
Okay.
He was so tall that the framework of the wooden framework toppled his cap.
Oh, wow.
He was so tall. And when he entered my office room, my son was using in my absence from Bangalore as his study room. He had KPS Gill's photograph in front of him because he was a great admirer of that man. And he saw that and he was amazed. He said, I told him the sentiment is exactly the opposite in my case. And he said, sir, I was writing my autobiography. I know that you have a very bad opinion about me. Can you tell me what... I said, I have mentioned it in the judgment. Punjab police can never be equal to the demands of human rights. The whole thing would have been over several years earlier, but for the kind of wretchedness they used the weapon of violence.
And this was the Prime Minister was, I think, Mr. Narasimha Rao.
Narasimha Rao.
Yes.
She told me, Gill himself told me, this is what Narasimha Rao said. If you have put it in writing, I will dismiss you. Narasimha Rao had in fact, my first reaction with him was so violent. There's a formal dinner for the outgoing and the incoming Chief Justices. And at the end of it, Narasimha Rao said, Chief Justice, you will find my relationship very cordial with you. I said, sir, please, the word cordiality will be proper with each other.
Proper. This is a story that I've heard from at least in this particular exchange. That he said cordial and you said proper, and I think it's a big conceptual difference. But I just wanted to ask, why did you use that word proper, just for our listeners?
17 letters addressed by my predecessors at the office of the Prime Minister remained not even acknowledged.
Oh. What were these letters regarding?
Some facilities for this thing, approvals for conferences, deputation of judges outside for this thing. The official letters would go for sanctions, financial sanctions had to come from them. And most of them were in relation to Indo-British, Indo-American legal fora and all that. And secondly, medical facilities for going to foreign hospitals for treatment. all those things. I had a bundle of them. And then the Prime Minister called on me. He was a very gracious person. Very, very pleasant and very affectionate reflections about his concern for the judiciary. He was a very cultured man. He was a linguist. But political compulsions are different. We are not concerned with it.
So, again, when you said the word proper, but what did you intend to convey to the Prime Minister?
That judiciary and judicial requirements must be taken seriously, not just as an administrative procedure. It must respond quickly so that there are so many things about administration. In fact, the one involved creating more chambers for lawyers. I thought a big issue. They had to give us a huge plot of land reserved for the guest house of the Kashmir government, Jammu and Kashmir government. And that was, the plot was allotted just behind the Supreme Court. The chambers were, additional chambers were built in my time.
Okay. Did you feel that that was respected by the Prime Minister then, the government then? The idea that a relationship between the judiciary and the executive...
No, his advisors, I'm told, were very critical about this thing. And they said it's not proper for the Chief Justice to have uttered that. Okay. That's itself a matter of propriety. That's what I call proper.
They turned your own words against you. But I mean, it's very interesting to note, because I think this is where controversy has taken place in the last 10 years or so, let's say approximately, where the relationship between the judiciary and the executive has, another word used nowadays is cozy. That the relationship seems to be more than cordial. It seems to be that they're on the same page about a lot of things. I wonder if you had thought about it. What was your views on that?
It all depends on the times and the context. Matters of great national interest and concern need to be dealt with at level. But more importantly, Human Rights Commission appointments and things like that, they are all matters of great national concern. Today, the most important issue is how suddenly we allow twilight to become darkness civilizationally. Technology, the outpacing every other system. It outpaces the legal system, judicial system. What will be the consequence? It will be anarchy.
Even when I practiced in the Supreme Court between 2009 and 2013, the reforms that you had initiated in your time as Chief Justice, they were still being spoken of very admiringly. They were still being spoken of with, that was the most impactful set of changes that we have seen in the way the Supreme Court is run. Not the judicial decision-making, but so much in the administrative and the technological reforms that you had brought in.
Justice Ahmadi, he was a great manager, a good judge. He had the greatest concern for the system that I had visualized.
This is one of the things which, in my time at the Supreme Court, the discussion was one Chief Justice wants to introduce a system like this. The successor Chief Justice immediately says, no, I am smarter, I know better. But how did Justice Ahmadi, did you speak to Justice Ahmadi? How did you get him to say, please continue this?
He came to my house after my retirement and talked to me about it. I told him, I don't want to diminish your enthusiasm and your ability by my limitations. He was a very fine judge, very fine administrator. I am most grateful to him. He was a great personal friend. We were neighbors and we traveled together. Ahmadi was a very fine man.
And I think that's great, because that ensured that continuity and ensured that there were about 4 or 5 years of these reforms.
But some Chief Justices reversed the timing from 4:30 to 4 o'clock. People think that every change is progress.
At that time, who were the important members in the Supreme Court Bar Association and the Advocates on Record Association?
Attorney General for some time, the Ramaswamy, G. Ramaswamy.
Yes, Mr. G. Ramaswamy.
Ramaswamy was the Attorney General, and then...
This is very interesting to know that there was this broad support that you could count on for making these changes and reforms. And, nowadays it's there has been more data-driven studies of the...
I'll tell you, it is a feeling of belonging to a family. That was the kind of personal thing with though we had very tough cases with the government. took some very tough stand on some issues. They are gracious people. I tell you, India has a high blessing of noble people. They may have some small faults, some peccadillos. If I'm born again, I would like to be a lawyer in the Supreme Court.
I hope that sentiment, of course, continues. It's a very different Supreme Court now, I can attest. From the time that you're describing, it's a much bigger Supreme Court, many, many more judges, many, many more lawyers. But I think
Krishna's graciousness in court is unparalleled. He is a very, very brilliant mind. He changed the vocabulary of law. And you see, some of his expressions were so outstanding, but at heart he was so good, so kind.
you've worked with 3 different prime ministers in your tenure as the chairperson of the National Human Rights Commission, right? Mr. Devegowda, Mr. Gujral, and Mr. Vajpayee. What was their impression of the NHRC? How would they conduct themselves with you personally and the body?
Though the impression initially I got their response was tongue-in-cheek, but later they said, when we went seriously about torture, a convention against torture, and things like that, they could understand the concern. And a mature politician is a greater assurance of security for the nation than a mature administrator. I think the vision comes from them, and that vision can inspire the bureaucracy. Bureaucracy is neutral. It is borderless. It can work anywhere, whichever way the political wind sweeps. But I think overall, please see how the support they have given to nuclear research, space research, how much of funding is done in a developed poor country. So it requires great political imagination.
We have a very different view of the politician. We have a very different view. Personally, how was your experience when you were in Delhi especially? And your term covered 5-6 different prime ministers. What was your interaction with them?
Our political atmosphere is, electoral atmosphere is different.
That's where I'm coming from. I wanted to know what was the...
Political atmosphere is perhaps not inconducive to good administration. Nobody opposes good administration. They may take advantage of bad administration. They even admire good changes. For Indian politicians, it is not to be written off as something totally negative.
This is what I've been trying to tell a lot of people, and your experience perhaps with the way...
And you talk to a member of parliament about some issues, you see really what he really feels about it. Though, of course, for practical reasons, he may have to adopt some methods which are not so delectable, but he is convinced about the values.
And were your interactions as Chief Justice with the Law Ministry, or did you directly deal with the Prime Minister and the Cabinet?
No, our administration would deal with the corresponding officers of the Home Ministry, because the Secretary General was a deputed IAS officer.
Right, okay.
My man was Gopal Sami, who later became Chief Election Commissioner.
Right.
He was my
Okay.
secretary. Excellent officer. And my Chief of Police Investigation was Shankar Sen, a noble man. He and I are even daily touch. He has written 2 beautiful books on Ramakrishna and Vivekananda. I have written the great forewords for those books.
Chief Justice Hidayatullah, when he was Chief Justice of India, that one aggrieved litigant tried to stab him in court.
Grover was injured in that
yes.
case. Justice Grover was injured. Hidayatullah I knew personally very well, and he was a very great lawyer. His knowledge of the legal lore was enormous. He was a very well-read man. You remember that case, Lady Chatterley's lover, Udeshi.
Yes.
Udeshi. Yes. I think 1965. Hidayatullah wrote a beautiful judgment. He found no artistic or linguistic elegance, any redeeming feature. And he said there's none in Lady Chatterley's lover.
But don't you think that judges should not be, artistically commenting on a work like this?
See, this starts from Shaw versus DPP. But in 1961, when a Chief Justice said, there's no area of immorality which is not law's concern. That famous statement broke loose a great debate, hard devouring debate on law and morality was the consequence. Our younger generation of lawyers are not familiar with this kind of trends. See, that's a great debate, hard-leveling debate on law and morality.
And I remember we studied it in jurisprudence. When I was in law school, we sort of examined those various issues and why Hart took the position that he did. Why did Devlin take the position that he did? A very interesting debate. But coming back to Justice Hidayatullah, did you have occasion to meet him? Did you have occasion?
A number of times.
Okay.
I suspect he was very fond of me. Whenever he used to come to Bangalore, he would stay with his brother-in-law, wife's sister's husband. His wife was a Gujarati Hindu lady. He's an Air Force officer in the Air Force officers' colony. He used to come and stay with them. I used to spend hours with him.
So what would you generally talk about, apart from the law and the courts? And
he was a Renaissance man, like Ravi. And he knew so much. They came from a very illustrious family. His brother Ikramullah became minister in Pakistan. And I think the Queen of Jordan was his niece. I think Queen of Jordan was, Mr. Ikramullah's daughter or some family related. I think somewhere closely related to Hidayatullah.
And your impressions of his contribution to the Indian judiciary and the law? And
he was just exactly the opposite of Krishnayar.
In what way?
See, when Krishnayar Bhagwati opened up this
public interest litigation
and resisting
letter petitions. He made a very drastic comment on that. I've referred to it in one of the pet scripts brought about in honor of Krishnayar. The exchange was very interesting. Hidayatullah said a king in the Islamic country had put a rope in front of his palace. Any aggrieved person could come and pull that and ring a bell, and he would entertain the complaint. Once a donkey came and rubbed its back. And that's the kind of parody. Krishna came down like a ton of bricks on Hidayatullah and called him Ayatullah. People don't read these kind of things these days. That's the problem. But what was the fundamental reason why Justice Hidayatullah may have disagreed with the whole idea of?
He said the judicial system is not geared up for that kind of instant spot justice. It has its own culture, its validity dependent upon the validity of the procedure. And the procedure was not merely essential, but procedure was, it has its own sanctity. And if you break the sanctity, you break the integrity of the system. See, that's why we say history of liberty is history of procedure. And of course, this is a different context.
No, that is right, because I think more and more people are also now taking up the argument that Justice Hidayatullah made. There is recently a book by the scholar called Anuj Bhuvania, who writes about why procedure is so important. But in your conversations with Justice Hidayatullah, was he kind of thinking also the consequences of PIL? Did he say that these kinds of cases should not be coming to court? What was his?
Yes, he was saying the way in which they are introduced into court will raise more problems than the problems they will solve. And he was critical of Krishnayar and Bhagwati.
And do you think, after having seen all of this play out in the last 40 years, how would you balance Justice Hidayatullah's views?
That's the right word. Right balance and the right sense of balance. More sense of balance. Our constitution is not merely a political, legal document. It is a political message. How you translate that message into action through the instrumentality of the judiciary is perhaps the greatest debate of our country. In fact, we were greatly influenced by the events in Europe. The Second World War had the most profound influence on the Indian constitution making. That's why the 1935 Government of India Act became the Constitution of India. It was not merely the old 35 Government of India Act plus two parts, the third and fourth. It's not just that. It introduced a new philosophy of interpretation itself.
What would this new philosophy of interpretation be according to you?
Perceiving in its proper perspective the problems of a feudal society grimly struggling to be reborn into a modern egalitarian industrial society. That process, what's your, first identify your role in that process. And if you identify your role, your duties will become clear. And I believe that the gang of four, as we used to call them, Chinnapreddy, Krishna, Bhagwati, and the Gujarat Judge.
Desai, Justice Desai.
Desai, the gang of four, as they were fondly called. Their philosophy is appropriate, provided the appropriate systems to implement that philosophy is in place. Otherwise, it go haywire. You begin to rule where Parliament must rule. Judicial lawmaking is a slippery slope. You don't know where you end. And that's why we go back to Dean Roscoe Pound's judicial alchemy and judicial chemistry. You can't create raw material. I think this is beautifully presented by C.K. Allen in The Law in the Making. This is a 50-year-old book. He says, what are the sources of lawmaking for the judge? It's not his personal impression. It is an established link between the objectives of the Constitution and the methods adopted by that. That connection must have a perfect grip over that connection.
And on that note also, I think when we put this out in public, we are going to give people a reading list. All the books that you have mentioned, sir, is an education in and of itself. So I think when we put out the recordings, we will put a list of books that people have to read to really understand the philosophy.
You must read Cash Nexus, that world we are in, Hutton, Will Hutton's, the state we are in, the world we are in, rise and fall of great powers of Paul Kennedy. Europe, in 400 years, they fought 1,000 wars amongst themselves. And how Helmut Kohl brought a European roof over Germany. We discussed it yesterday. That kind of a thing, in one talk when the foreign minister Krishna was present, I explained to him how that ideology should inspire South Asian nations, how we have a South Asian Union. And there's a very interesting inspirational episode to throw some light on this kind of thinking. When India and Pakistan separated, Gandhi went to Jinnah and told him, two things we'll have in common. We have parted as brothers. Two things we'll have in common. One is common defense and foreign relations. It will be a limited federation for that purpose. Jinnah rejected it. And just imagine the kind of impetus that we'll get for developmental resources if Bhutan, Sikkim became part of India, Burma, Singapore, Nepal, all of them became a South Asian Union like the European Union. At least for common foreign policy and defense. You reduce so much of expenditure on you make ammunition in the time of Cold War and justice in the time of hot war.
That's true. And I think that is something which a lot of people do think about and talk about.
When SARC emerged, that was the ultimate idea.
Yeah, but unfortunately, SARC isn't effective anymore. And that was the idea, but it isn't effective anymore. But coming back to just the earlier discussion which we had, on the one side, we talked about Justice Hidayatullah's approach to this. And we have briefly mentioned Justice Krishna Iyer, and you call him an Aristotle. I'm particularly interested the choice of Aristotle to describe Justice Krishna Iyer.
See, Aristotelian politics, it emanated originally from Plato. Why do people organize themselves into a society, into a political and a social society? He said there's only one purpose, namely to give to each member, provide him with the highest opportunity of realizing his best self. This is social contract. And on this they built up. And Plato and Aristotle gave muscle to, when he described the role of the military, the power, state's power, how it should be channelized. He was a Chanakya in that sense. Machiavelli, Chanakya, Aristotle take their views on political organization and means of protecting them. Very interesting parallels emerge.
But why would you think Justice Krishna Iyer would be Aristotle in that way?
Krishna Iyer is an enormous mind. People think his diction was his strength. No, it was his limitation. It was his limitation. His conception of the social contract As a result of, I think Krishna is vindicated by two books that came up in the last 2 years. One, director of the London School of Economics, Shafiq, or some lady, she wrote a book, What We Owe Each Other. And the same title on the other side of the Atlantic, the man who wrote a foreword to Rawls' Theory of Justice, he wrote the book on the same title. Contemporaneously, perhaps it's not knowing each other, they have produced this kind of Aristotelian and Platonic concept of society.
And where do you think Justice Krishna Iyer's view came from? I mean, you say he was one of the finest minds that this country has produced.
Krishna Iyer was philosophically a contradiction. He was a communist, but he lived a lavish life. He had a big estate near the sea, and one border of his estate was the sea itself, in a beautiful private tennis court. And he would change a foreign-made car every year. And that is his kind of mind. It is not the bohemian kind of aspect only. He was a Spartan. But the bohemian side of it was a kind of a display of the contradictions. And personally, he was a great friend, capable of great friendship.
A lot of people have mentioned that his capacity for friendship, and you mentioned one incident last time, of course, when he came to meet you at 4 a.m.
With his daughter and granddaughter. I was coming down the steps, I was still sleepy. Just had a hurried bath, and then I had to catch a flight at 6:30, and the staff were waiting to take me to the airport. When I came down the steps, I saw him standing. At most that he must have left home by 3:30.
No, that's very interesting. And did you have a lot of interaction with Justice Krishna? Although you didn't overlap on the bench, I mean, he would have retired by the time I think you made it to the Supreme Court. Did you sort of meet with him, catch up with him on a lot of...
Whenever he came to Delhi and stayed in the Kerala Bhavan, I used to go and call on him, spend some time with him. In 8 days, he was not very well. Health-wise, he was not very well. At Krishna Iyer is Krishna Iyer. You can't have another Krishna Iyer.
And I think a lot of people express that sentiment. But what were the topics that you generally would talk to him about? What would you discuss?
He and I and Verma, three of us were invited by Manmohan Singh to suggest the way of judges should be appointed. Krishna Iyer had his own notions of the eligibility of a person to be nominated as judge. Verma and I, the three of us, I think there was one gentleman who was catalyzing this kind of debate. And this is a retired IAS officer, a resigned officer who runs a NGO in Hyderabad, Prakash Narayan or something.
Prakash Narayan, yes.
He was coordinating this. He was very close to some press organization in Hyderabad, requested me to head a jury to give a Lifetime Achievement Award. And it was, there are two names that were tossed up. One was Mr. Advani, the other was Manmohan Singh. It was a very interesting thing. And Prakash Narayan was one of my members of that committee. It was the personal public perception of personal and public philosophies of these people came to be discussed. There were 10 or 12 journalists, top journalists were in the committee. The discussion was very spiritual heights, not the individual. How do we put a man's performance in the context of the national compulsions of the day?
That's very interesting. And just to come back to the judicial appointments part of it, what were Justice Krishna Iyer's specific notions about who should become a judge?
Krishna Iyer was a classicist. He wanted the political and economic philosophy of the person, known commitment to the values of social and political philosophies relevant to the times. He searched more than legal scholarship. I was of the view that unless you have a vision of a judge has a vision of as deep as the ocean, as vast as the sky, is familiar. Otherwise, appearing for a judge will be a punishment. He's asking the same question over and over again. That's good for a country like Canada. Good philosophers sitting there. In fact, the Canadian system has this. If the statute is challenged, the judges have a duty to have a conference with the executive and the legislature. And then they say, we are going to strike down this law. By the next hearing, you amend the law and bring out. This is a consensual constitutional process. It's a participatory thing. That's the specialty about the. In fact, when the Quebec secession case came up, they produced a beautiful document. They asked me my opinion, written opinion, for the Karnataka-Maharashtra border and the interpretation of the State Reorganization Act. I said, this is not a thing which is enforced by law. Law recognizes the political consensus.
That's true. And this is what is, I think, also in the part of the debate right now. Do we want a good lawyer to be a judge? Or do we want a good, aware person, which is, I think, what Justice Krishna Iyer wanted from a judge?
The second thing Krishna Iyer wanted, I took for the view that unless you are familiar with all branches of the law, reasonably, it will take a tournament. The case goes on being argued any number of times. There's one Justice Pense, who was Chief Justice here. He was such a sharp legal mind that it won't take half a minute for him to perceive the core of the dispute. In fact, Palkiwala once said when he was superseded, he's the best judge in the country.
Justice Pense here in Karnataka.
He said he's the best judge in the country. That's what Palkiwala made a public statement.
And this has happened to a lot of very good judges since.
As I tell you, injustice in a particular case is the test of validity of the system itself, because it is an abstraction, a generality. Some exceptions are bound to be there, and that proves the rule. The exception proves the rule.
And did the three of you come to some consensus as to, like Justice Verma, Justice Krishna, and yourself, did you come to some consensus on advising the government on who should be a judge and so on?
The Prime Minister, at some point of time, I felt that he withdrew from that idea of sponsoring a change. Maybe politically, because I think Jayaprakash Narayan must know why it petered out.
And what do you sort of see at the collegium system as it stands right now?
I think Alexander Pope said, for forms of government, let fools contest. Whatever is administered best is best. For forms of government, let fools contest. Whatever is administered best is best. So there is no silver bullet or a magic pill for doing it. The names of judges are tossed up by not judges, by a system. Every public institution must reflect the composition of society. And that is the political strength of each institution, that it reflects the composition of society. And American Supreme Court has a Hispanic, has a black, has got a Jew. All this is a set pattern. They accept it. Here we are afraid of accepting certain political realities, that society must have faith in the institution. And judges, knowledgeable lawyers argue the matter and right or wrong. How is that to say out or not out? This depends upon the quality of assistance you get.
One of the points of the discussion that is also happening in the context of the judiciary is the composition of the bar. Who gets to be a lawyer?
Exactly. There are not sufficient women. You see the poverty of numbers in the bar itself. It has its own force. In fact, I remember that beautiful Hamlin lectures, was that beautiful book, Protection from Numbers. Protection from numbers, for example, labor unions and all that. The kind of challenge that the numbers pose. It's a beautiful book.
I mean, on the composition of the bar and representation on the bench, I think you were in the Supreme Court when the first woman judge was elevated to the Supreme Court, Justice Fatima Bibi. For us, it seems like a very long time. But what was the reception in the court? What was the reaction from the bar? What was the thinking at that point of time?
Of course, Fatima Bibi had a political background. Her, I think, brother-in-law was a leading Congress leader. She was a very good, gracious lady. She later became my colleague in the Human Rights Commission. She later became the governor of Tamil Nadu. Her appointment was received well, not criticized. She rose to the level of great Anna Chandy in the Kerala High Court. She made a great name, Anna Chandy. In fact, she and one of the earliest women judges in the country.
It's something which I think it's been pointed out repeatedly that there aren't enough women and very few women have made it to the Supreme Court. But One woman judge who is currently in line to be the Chief Justice of India is, of course, Justice Nagaratna, whose father was also a Chief Justice of India, Chief Justice Venkatramaya, and possibly your colleague also on the Supreme Court and the Karnataka High Court. What memories do you have of him? How do you remember him in that
He
context?
was a very gracious man. He was a very fine judge, fine lawyer, very fine lawyer. He was a great personal friend of mine. We were together in the High Court. I think he moved to Supreme Court in 1978. I became a judge in 75. We were 3 years together here. In Supreme Court, we sat in a number of constitutional benches, including the infamous Bhopal case. He's a very fine judge. Venkatramaya had comprehensive knowledge of both constitutional law, personal laws, and he was very much respected in the court by the colleagues.
And when you moved to, I think he was probably the only judge from Karnataka when you moved to Delhi also?
No, Jagannath Chetty was there.
Yes, Jagannath Shetty was there. So there were 3 judges from Karnataka at the same point. And did the 3 of you sort of meet together? Did you introduce each other to?
No, Delhi is a place where this kind of personal contact is, you are too busy with life in such a way that you can't choose anything. You are thrown into something and you have got to survive there.
But how did judges get time to interact at all, even in the court or outside the court?
Whenever a case came up before the bench, there's an intense concerned debate about the justice of the matter. And if perceptions of the merits of the case were inextricably interconnected with our own sense of justice of the matter. In one case that troubled me, you remember in 1963, there's one case, we read that. You know how positive rules of interpretation can sometimes miss out on the justice of the matter. Nagalinga Goundan or something is the name of the case. 1963, 1182 is the page.
This was in the Karnataka High Court?
No, Supreme Court.
Supreme Court.
Came from Tamil Nadu. They missed the point. The 1929 amendment of the Transfer Property Act, it says mortgage by conditional sale can't be countenanced at all, even as a plea, unless the reconveyance, the covenant is incorporated in the same document. They recorded a finding that the purchaser outreached the plaintiff, Nagalinga Gounder, Simratmal, the banker, who took a document. He outreached and took a sale where a mortgage was intended. And then said, having got to the amended law, we can't do anything, and dismissed his plea. But it failed as a sale itself. There's no consensus. You record that what was intended, it may not be enforceable as a mortgage, but it fails as a sale. And this requires a good trial lawyer's perception of the implications of the very facts. Say, when you say it is not a mortgage, your own finding that it's not a mortgage shows that it's not a sale. There's no consensus. In fact, Anson defines inadequacy of consideration. A pepper grain, he says, is adequate consideration, unless the inadequacy of consideration is so gross as to shock conscience and amount in itself to conclusive evidence of fraud. That's the statement, apparently contradictory, but it's full of legal message.
And this is something that I guess judges grapple with all the time. And a lot of people, and those of us on this side of the bar, we wonder, do judges talk to each other about a case that goes on? How do they debate?
There's an intense debate. Contrary to popular impression, they don't simply sign off in concurrence. Every case, judge has his own perception, and they, among themselves, they put it across. Somebody must write about this, how they feel miserable when they are faced with a case where law is against justice, against their perceived sense of justice. What kind of torment they go through.
Did you find that in any particular case, that you felt the law was, as you saw it, against your sense of justice in one particular case?
Yes, a number of cases. One instance I'll give you. A boy, an 18-year-old boy, came to the father's grocery store to relieve him to go home the father to go home and have his meal and come back. Some food inspector came, purchased a small quantity of some condiments. It was found contaminated. He was prosecuted at the age of 18. He was prosecuted for adulteration of food act. The first court acquitted him, appellate court convicted him. When the case came up to the Supreme Court, it was 30 years. And in the meanwhile, he had married and begotten children. And the High Court had convicted him for 2 years of rigorous imprisonment. When the matter came before me and my brother judge was, you must find out how we can get out of it. I said, it's a social defense legislation. Social defense legislation. You can't find the excuse for it. In fact, in England, they had in the package food, they make 1 million packets. In one of them, there is a worm. They said this is a belt, a white belt, this is some kind of food grain. We run this and we pick it up and physically supervise it, but some mistake. But they said no. The social defense legislation must be interpreted more strictly. And we upheld that view. Then ultimately we had an intense debate how to deal with it. No, I told my brother that, look here, I know the pain in your heart. You may dissent, but he said, no, your logic is so compelling that I can't take the risk of contradicting it. Then we appealed to the state government to remedy the sentence, the substantive part of the sentence while retaining the fine. The government promptly did that. It's a very interesting case of one of the dilemmas that it was 30 years after the alleged offense and the ultimate culmination of the whole process of great justice, Franz Kafka's Temple of Justice. This door was only meant for you. Now that you are dead, I'm closing it.
Yeah, and I think that's sort of what all judges grapple with, I suppose, and you've put that very beautifully for us, how this law can sometimes go against notions of justice. One of the things that you mentioned last time was the importance of oral advocacy, that this whole tradition that we have of arguments across the bar and the power that it contains. And I thought we could talk a little bit about the lawyers who appeared before you, how you knew them, what was your impression of them. And you mentioned Ashok Sen, who, again, I have not seen him. Unfortunately, he's a name that my generation is not very familiar with. But you and many others consider him one of the finest lawyers this country has produced.
Of course. In fact, in a corporate matter, we had some problem of understanding. Our knowledge of the corporate laws was so limited that we wanted to assist. He took off his gown as an amicus. He argued the matter in such a beautiful way. He had perhaps the finest law library of any lawyer in India.
That is something that I've heard when I was practicing in the Supreme Court. Almost all the lawyers used to agree, and there was a little bit of envy that why can't we access it anymore? I don't know what has happened to that library. But what was this?
See, my appeal to Ravi is you must set up a beautiful law library in Bangalore where students, scholars, journalists could come and use it. You can ask any of his great clients, billionaires they are, they can have a library. The physical touch of the book. I gave about 1,000 beautiful classics, almost 1,000, 3 editions of Halsbury. The first 1906 edition with my grandfather was a judge, his signature on it. And the Empire, English and Empire Digest, 20 volumes. Halsbury was about 16 volumes in those days. And I was chair of the editorial for this Halsbury's Laws of England by that publisher. The new edition came, 4th edition. I was chairman of the editorial committee. And surprisingly, one judge, I think he was a serving judge, he wrote on, contributed a chapter topic on Halsbury, expertly done. I think he was Badr Ahmad or something.
Badr Durraiz Ahmad, Justice Badr Durraiz Ahmad of the Delhi High Court, yes.
So, yes. He showed beautiful pensions for academic research.
Yes, he is true. I mean, among his judgments are genuinely works of academic literature in my view. But again, coming back a little bit to Mr. Ashok Sen, what apart from his advocacy, right? In what are the kinds of cases that he used to appear in? What is the impact of the kind of work that he did?
He was thorough in every branch of the law. And I think he was, academically he was amongst the, I can't say the best, because I have not seen all of them in my short tenure. But he was undoubtedly amongst the topmost lawyers in India. There's no branch of law in which he didn't have familiarity.
And it's very remarkable because the instance that you gave, that in a corporate matter, that he assisted the court as an amicus of his own volition to ensure that...
we requested him.
Oh, okay, you requested him. Huh?
He said, apart from your appearing for a party, we would like your independent assessment. And he argued the matter. I think it went against his own clients.
But I don't think any client would have dared to say, how dare you.
See, at that level, nobody... Nariman is one such. He's a remarkable mind. They're all a class by themselves. And Chitale, Dr. Chitale was another very good. And then there used to be one very fiery lawyer, Garg, T.K. Garg.
Speaking of the best at that time, when you were in the Supreme Court and when you saw them in that period of the 80s and the 90s, one other name which we very briefly mentioned in our previous conversation was Mr. K. Parasaran, who was then the Attorney General. So I've heard this story. I don't know how true it is, but I thought I'll check it with you once, that you used to meet Mr. Parasaran before court started in the Supreme Court canteen to share breakfast of idlis or whatever was.
No. Parasaran was a very close friend of mine. He was just about a year older than me. He was the Attorney General when I went there, and he was the first to break the news that Rajiv Gandhi wanted me, in spite of the fact that, see, it is an exaggerated notion that I declined to see the Prime Minister. It's not that. The Law Minister suggested that every nominated judge name recommended by the Chief Justice of India calls on the Prime Minister. I said, I don't know whether it's a desirable thing to enforce on the time of the Prime Minister. I have no invitation. And that's been exaggerated, saying that I won't meet the Prime Minister. It's always a pleasure for anybody to meet the Prime Minister of his country. And Rajiv Gandhi was known for his gracious manners as well. But I said in this context, it would only mean that I am requesting him subtly to endorse my nomination. I don't want that. And the conversation ended a little unpleasantly, in the sense he was saying everybody has done that. I told him, don't expose others to this thing. They must have done it on invitation. I don't know. In fact, I didn't mention this to anybody. And the day I retired, the same law minister was the governor of Sikkim, came to my house. He had breakfast with us. Number of people used to call. At least that day I had 200 visitors wishing me farewell. And he was there for the breakfast, for lunch, and told this story to everybody.
So you had said that Mr. Parasaran was a close friend, and I suppose this friendship started before he went to Delhi to be Solicitor General and Attorney General.
It started with my admiration for him. He had a great reputation as a very fine lawyer and a very ethical lawyer. And it was the first time he must have appeared before the High Court in one or two matters. Personally, I never knew him. It's only on the day before my name was announced, he telephoned and announced disclosed his conversation with the Prime Minister. Prime Minister seems to have said, I'm proud that judges like this, please announce his name tomorrow.
And when Mr. Parasaran appeared before you here in the High Court, what were like your impressions of him?
He was a very pleasant, very persuasive, very knowledgeable, and a very, very pleasant lawyer. The capacity to put across things in a very pleasant way. Of course, you had big experience in the Bhopal case. In fact, that's a very difficult case.
I can totally imagine. And he also appeared when, of course, you were in the Supreme Court. He was Attorney General, and then he appeared in a lot of cases. What was your experience as a judge hearing him along with, say, other greats like Ashok Sen? And
see, some of these top lawyers gave a sense of comfort to the judges that they are being led in a correct way. They never pitch the argument too tall. For example, taxation. Very interesting cases came up, and in one case it was argued the power of taxation is consummated. For example, a shopkeeper sells a bottle of perfume. The moment you exercise the power of sales tax, is the power of taxation consummated? Supposing there is a law on taxes of luxuries, expenditure tax, sales tax, and if you sell a bottle of perfume, you can tax it for the sale as a perfume, as a luxury. Aspect doctrine. This is what Palkiwala's argument I didn't accept on the basis of the Canadian precedents of this thing. So that's greatly criticized.
And you said something very interesting, and I don't think other judges have. I have not heard this from a judge. Great lawyers give you a sense of comfort as a judge, and just to talk a little bit more about that, how do they give that sense of
clever
comfort?
lawyers give you a sense of caution. Great lawyers give you a sense of comfort that you are being not being nose-led into a wrong galley.
What was the kind of arguments that they made? How would you know that I am in the presence of a great lawyer here?
The unspoken part of the gifts of morality is the argument. In your talk, you know the personality of the man. There is a sense of perception. When you and I talk, my talk is tongue-in-cheek, or I speak from my heart. This is what Anatole France said about truth. It's a shining quality which denies to deceit and falsehood altogether. You say truth and understand in the same way in which you mean it. This is a beautiful statement of Anatole France.
No, that's absolutely true. And I suppose the way in which the senior advocate makes that argument, the way the best lawyers do, you know that they mean something. You know that their word has value.
It's not a tongue-in-cheek argument.
Yes.
If it is so, this is a possibility, this view is also possible, they will caution you before consuming it totally. There's a subtle sense of conveyance of a sense of caution when they put up an extraordinary tall argument. What's your own experience as a lawyer?
My own experience as a lawyer, was probably too limited. But having seen a lot of senior advocates argue in the Supreme Court, I think one of the very important things which I saw which made a difference was that ability to cut out all the other things which, other lawyers will tend to talk about and get to the heart of that matter and say, look, this is all I really want you to decide on. This is what is the real crux of this issue.
See, that kind of simplification, some lawyers are very eminently capable of. Some of them complicate the issue. You have to go through the maze, unsnarl the ball of twine. It takes a little effort, intellectual effort. But some people put it so beautifully. Chidambaram is capable of presenting a case absolutely simplified without all its entanglements. He can isolate strands which are relevant for the purpose. For purpose of clarity, he is a shining example of clarity and simplicity of presenting a case.
And speaking of legends in that way, I think also since you've mentioned Mr. Nani Palkiwala, how did you know him? How did you interact with him?
I knew him personally in the sense once he came to present, I had a long conversation with him. Of course, Palkiwala is Palkiwala. You can't. But when D.N. Pritt, the South African barrister, was asked, who is the best lawyer in the country? Oh, your Attorney General Settleworth. He said Settleworth. He mentioned Settleworth. D.N. Pritt said, oh, your Attorney General Settleworth. Palkiwala is a great human being, more than a great lawyer. They are all different type of human beings altogether.
I have heard a judge say this, that Mr. Palkiwala, when we hear your arguments, we need to take a break because our minds are so engaged by your argument, we will not end up hearing the other side properly. Did you get that sense?
You're right. But one thing, Kanhaiya Mishra was the opposite, was the equal man. In fact, in the Brits case in Bombay, Palkiwala was on one side, Kanhaiya Mishra was on the other side. Palkiwala in the appeal, he lost in the trial court, he went to the appellate court. He complained to the judges. Kanhaiya Mishra mesmerized the judge below. Chakla said, how are you sure that he is not going to mesmerize us here? That's a great...
I've heard this particular story from Mr. Andhya Rujana also, who was in the Bombay High Court at that time.
Andhya Rujana is a great lawyer. Great lawyer.
And about what was your interaction with him? What was your experience with Mr. Andhya Rujana?
Anjarjuna was a typical English barrister and absolutely correct. And he would evaluate every argument he presented before court beforehand and satisfied himself that it's worth being presented. He would sound the coin, and he gave a healthy ring, he would sell it. Otherwise, he won't sell a coin without tossing it for a healthy ring.
And that's very interesting, because this tradition of...
In fact, I went to his house to invite him to join the court. He declined.
Did he say why he declined?
He said he didn't give anything. He said, I'm quite comfortable as a lawyer. He was very close to me. I went to his place, requested him to accept. I went to 4 lawyers, Dipankar Gupta, Iqbal Chagla, Setalwad's son,
Atul
Setalwad, and Anjarjuna. All the 4 declined.
I'm trying to imagine what the Indian judiciary would have been, even if at least 2 of the 4 had, given their work and given their talents, which we have seen in the public domain. I'm trying to imagine what it would have been like. But 4 fantastic choices. But it brings me to something which you as Chief Justice were also involved with, which was the appointment of judges. What were the challenges when you were the Chief Justice?
We didn't have sufficient information of a person to assess him whether he's going to be a well-conducted judge. Knowledge-wise, we know the cases he has argued. We know his prosperity in the profession. That's an indication of efficiency. People say earning is no indication. No, it's not necessarily so. It may be partially true that it is not conclusive of his ability, but it's one of the indicators.
So how did you then get information? Because one is you are appointing, or at least you're in charge of appointment of judges across the country. You have to gather information about lawyers practicing everywhere from Chennai to Punjab to Guwahati to Gujarat. How did you go about this?
Well-trodden path is the best path. There's a process. It's a product. If the process is right, the product is not going to be wrong. It might not necessarily be very right, more right than the process. But we had to respect the process, because once you establish a process, to be wiser than the law is the very thing by good laws forbidden. To seek to be wiser than the laws is the very thing by good laws forbidden. So we had to limit our intervention. You couldn't make any private inquiry and all that unless there was some need to do that.
And this would mean that the files would come to you from the high courts?
Yes, come to that. And normally each Chief Justice would take conferences in number 2 to be sure of this thing. That's before the collegium system.
What sort of information would come to you from a Chief Justice? Without going into specifics.
There used to be a format which necessarily meant elimination of negative things. Whether you had a criminal case against you, whether you had this thing, or they're all negative things. And the positive side is the impression of the High Court that ultimately must prevail. How am I wiser than the Chief Justice of the High Court who will do that? In fact, once I'm venturing into an area where my good friend who wrote an article on me last month, he said, whenever you go to Bangalore, go and meet him. Kachu, whoever goes to Bangalore must go and call on Venkatachaliah. And he mentioned my name, he'll give an interview. He also said that. You see, he did one thing. After he became Chief Justice of Chennai, he came and called on me. He was a good friend. There's more personal relationship with him than the official relations between the colleagues in the court. He said, I have been appointed Chief Justice of Madras High Court. What advice would you give me? I told him, I have no stock of wisdom to advise you. Your esteem of yourself is such that everybody is afraid of saying anything. I told him, if I were the Chief Justice sent to a High Court like Madras High Court, there's a great tradition, they started High Court. If I go there, I must first establish my intellectual credibility and credentials before getting to administrative reforms. Nobody will respect a judge who tries to think of the administrative matters, except to the extent it is necessary. First is list all the full bench cases that are pending in the court. And you are capable of deciding them with great ease, with your knowledge and experience. First establish your credibility as a judge, then as a judicial administrator. Then how do I go about appointing judges?
What would be your impressions of J.S.
He was a great man, sir. He was a great man. He was a very moralist, lived a clean personal life, and man of high values. And he had capacity for strong friendships and loyalty. He was a great judge, a great man and a great judge.
You had your areas of differences. How did they get resolved?
You don't need to have resolved any difference because our differences were marked. Not one constitutional bench judgment. I think we must have shared 5 constitutional benches. In each he dissented. In Sikkim case, he dissented very violently. I took a different view of the conception of tribes, not merely sections of society, religious basis. Tribal culture is its own significance in democratic this thing. My construction on the provision was entirely different. And 2 judges, Sharma and Verma, dissented. The 3 of us took the thing forward.
When the arguments were done, how did the judges sit down and discuss their views? Did you...
Hours together, they would stand in the corridor and discuss. To the annoyance of our mess carriers, they would be standing there. Vociferous discussion would be happening in the corridor when you're walking back from the court or walking into the court.
Did you continue these discussions until the moment the judgment was ready, or at some point you realized, okay, our differences are irreconcilable?
At some point you give up persuading the other man and then send your draft. This is what happened in Antule's case.
What prompted this dissent from you? Did you feel that?
There is 2 things. Does a judicial pronouncement become a nullity? Mirajkar was the case. And if it's a nullity, can you ignore it? And is the kind of nullity which entitles the affected party to ignore it and say it's a nullity and is of no effect? Or does it require to be set aside? If it is required to be set aside, then it is not a nullity. It requires to be declared a nullity. It's not a nullity till it is declared so. Wenfleet and Collateral Challenge to Judicial Proceedings has a beautiful chapter that people don't know, have not read. That occasion I took to explain the concept of nullity in public law in one case in which London and Clayside case, it's a spectrum. Some nullities can be ignored and you can discretion to disobey. Discretion to disobey when you are entitled to ignore it. For example, the Sub-Inspector of Police and Income Tax Assessment Order. You can ignore it.
Justice Krishna Iyer's judgment from Gujarat.
74.
Yes. It was an externment order where he said that you can ignore this nullity.
We are not setting aside, we are performing the obsequies of some Khan was the state of Gujarat.
State of Gujarat. It is something...
74. But he left the fundamental question afloat. That was answered by the English House of Lords in the Clayside, London and Clayside case. He was saying nullity is a spectrum. Wenfleet says collateral challenge to judicial proceedings is a classic. Rubinstein's jurisdiction in legality is again his doctoral thesis printed. So it is not an open and shut case in every case. Some cases require a declaration, some cases entitle you to, for example, Entick's arrest. He defied. Ultimately, the old case, Entick's case, the Englishman's home is his castle and all that. There's no absolutism in law. Context is everything.
You have dissented. There have been judges who have dissented in cases where you have been the majority. Is it something that you encouraged as a judge to say it's fine? Or because there is, and I'll tell you where I'm coming from with this question, the number of dissents has fallen dramatically in the Supreme Court in the last 2 decades, at least from 2000 onwards. You will see that the number of dissenting judgments delivered by judges has decreased. And some people sense that this is possibly because the Chief Justice is kind of constituting a bench where there will be agreement. When you were Chief Justice and when you had this power of the master of the roster, did you, in some senses, know that perhaps these people will take different views and I don't mind if they take different views?
Right. That is the contribution of judiciary to the evolution of a sense of justice in the country. If the courts don't debate issues thoroughly, leave it to popular opinion to push things, you must act as a foil to democratic acts of electoral despotism.
And that's a very interesting link that you make, because the dissent, let's say in an important constitutional case, the dissenting judgment is not just a judicial function, but also a democratic function.
You are absolutely right. People may not like that kind of analogy, but that is the vitality of a nation and a democracy. It's absolutely necessary that if you put 10 old men into a committee, I'll give the report in advance what they will write, and I'll tell you the exact words in which they will convey their unanimity. If you have an old man, a young man, some women, girls and women in the Constitution, the report will be vital and sizzling.
No, that's an important thing, because this is what I have had occasion to discuss with Mr. Parasaran also. His point was that a constitution bench, it's not better just because there are more judges, but because those more judges talk to each other. That 7 is better than 5, not just numerically, but there will be more debate and discussion.
There's one author who said, the time we were prepared to waste in discussing with each other is the essence of democracy. The time they are prepared to waste in discussing matters with each other is the essence of democracy.
Now that's very beautifully put, and I think that is perhaps what...
this sentence I have used in a foreword I wrote to Justice Anand's book on Kashmir Constitution.
A very important book, given that the hearings are going on in the Supreme Court, even as we speak right now on Article 370. But just to come back...
The whole concept of democracy is an open and shut pattern. Is the most misleading concept. Democracy has no fixed boundaries. Democracy is always an evolving or constricting, expanding or constricting thing depending upon the civilizational pressures, energy sources. My goodness, to encapsulate it as some doctrine is the first fallacy we make, that is a fixed doctrine.
No, and that's a very important thing, because it comes even within the judiciary functions. And I guess the importance of dissent is to bring that democracy into the court also, into the way the court functions also. But your personal relationship with Justice Verma...
That is one of the finest rewards of my life. I rate my personal relationship with him and even Sharma. Verma, after retirement, came and stayed in my house as my guest for 1 month.
Here in Bangalore?
In Bangalore. Sharma stayed with me for 2 months. After retirement, our personal relationships were so sacred. I even till today remember touching their feet, though they were younger to me.
That's very moving to hear. But what do you think made you and Justice Verma or Justice Sharma get so close to each other in the Supreme Court?
He looked like a despot, but they're two Democrats. And he had a high sense of judicial values. And he wouldn't care for power and authority, and he would never bend in front of power or might. He's a very self-respecting man. He cared more for his dignity than for his life.
Now, that's a very important and a very powerful way to put Justice Verma's personality together. What sort of kept your relationship going after you both had left the Supreme Court?
See, the distance did a great damage. If I had been in the same town, I would have called on him every day. Constraints of time, constraints of space, constraints of financial support. Otherwise, I would have loved to spend a lot of time with him in a hill station and discuss matters for old time's sake. But that didn't happen. My greatest regret is that after retirement, I didn't prepare myself to be able to spend some time with them together. Once I contrived to spend 3 days in Nandi Hills with him. My curiosity is to see how their minds work. I can see what are their priorities. Money was not his priority. Property was not his priority. His priority was deep concern for the quality of the judiciary. I said, because you have nothing to do. Why are you bothered about things in which you have no control? He said, no, brother, this is not so. And he was a great admirer of that gentleman who edited the Chief Justice of Madhya Pradesh.
G.P. Singh.
G.P. Singh. Guru Prasanna Singh. Right, Verma spoke so highly of him. I went all the way in a train to Jabalpur and touched his feet. Somebody who took a photograph and published it.
What did you generally talk to Justice Verma about? What were the areas that you both
He
enjoyed?
spoke about the bar and his colleagues, Hidayatullah and Madhya Pradesh, the judiciary, the high courts and all that. He passionately and incessantly spoke about the judicial process indirectly in a very concerned manner.
And what were the other interests that you shared in common?
Nothing. Some good films. We would discuss some good films that we had both seen and enjoyed.
It was just the judiciary and the law, and
Some beautiful English movies.
otherwise mostly your discussion would be about the law and the judiciary.
Generally about quality of Indian life and what's the future of India in the Comity of Nations. How judiciary can make an effective change, not in actually changing situation, but showing the way by how they conduct themselves as exemplary. He was absolutely unforgiving of any lapse in judicial personnel.
Do you think the Bangalore principles, as they're now called, do you think they're a good guide for that? Or how would you sort of tell a person who has just become a judge what conduct
See,
is?
it all depends upon the values that he has inside. Some people look up to worldly goods, comfort in life. Their preferences and associations are different. Those who have too much of exaggerated notion of the importance of their office are also a little deluded. You must know it's a beautiful, exciting democratic participation. You have an opportunity of solving people's problems to the extent you can in a just and moral way.
And, this is something that we bring to the current context. And I'm sure you would have seen the judges' press conference, which took place in 2017. To me, and I'll tell you where I'm coming from, in your time, there was, even within disagreement, there was cordiality. Of the instances that you have mentioned in public and elsewhere, that cordiality seems to have broken down. And I was wondering what was your take on it?
See, it's a cultural issue. It's a reflection of the mood of the society. If I don't know, there's no justification at all for any judge to be rambunctious about a matter on which he may have even a just difference. He can't use wrong words to convey even his right feelings.
And do you feel that they shouldn't have...
To put it strictly from definition of dignity, you can't depart. You have accepted notions of dignity in society today at all costs. Even if you are abused in the virus language, you can't depart from the rectitude of expression.
And so to that point, you'd say that even if those 4 judges had a good reason to be upset with the Chief Justice, they shouldn't have gone to the public in
the public also, they didn't use any accusatory expressions excepting some affront that they couldn't put up with for the time being. If they had sat down, taken a deep breath and thought about it, they would have done it. But I am only thinking what might be the intensity of the provocation. For 4 judges suddenly thinking of abandoning the conventional methods of communication. Is it the intensity of the provocation or the importance of the issue involved or their own kind of a sudden impulse of revolt? I am not able to see, but that's an eye-opener for the judiciary itself. Why such a thing could have happened at all?
After his tenure as Chief Justice of India, Justice Venkatachaliah was appointed in 1996 to head India's National Human Rights Commission, the second CJI to do so. He held this office for a period of 3 years, helping to shape this important institution. Following this, Justice Venkatachaliah was appointed as the chairperson of the National Commission to review the working of the Constitution. This commission was set up in February 2000 by the then NDA government under Prime Minister Atal Bihari Vajpayee. The ostensible purpose of this body was to suggest amendments to the Constitution on the basis of the experience of the last 50 years without tampering with the basic features of the Constitution. In the next episode, we will hear Justice Venkatachaliah reminisce about the legal and political figures that he crossed paths with during the course of his public life. This episode was recorded at the Indian Institute of World Culture in Bangalore And I'd like to thank the team and staff at IIWC for making this possible. I'd also like to thank my colleague at Vidhi Bengaluru, Pratiksha Ulal, for her research help during this podcast.
You have been listening to BIC Talks by Bangalore International Centre. If you like what you heard, do follow us on social media. Keep up with our programming by signing up for our mailer on the website or leave us a review or rating on Apple Podcasts or iTunes. The crew that makes these podcasts possible is Gaurav Krishna and Ishan Gupta on sound supervision and production, with support from S. Sarunaraj and Raghu Tenkaila. Artwork is designed by Chandni Venkataraman of Crisscross Design Studio. Don't forget to subscribe to our channel on your favorite podcast platform. It can also be accessed on our website, bangaloreinternationalcentre.org. This is Lekha Naidu signing off on behalf of everyone at BIC.